that it was important enough to tell his lawyer that he got a form letter, it would say, we have changed the charge under which we're proceeding with your prosecution. Technical change in my mind, especially as it relates to a pleading, would be a misspelling of a word. Or we said the hearing's at 2, not 4. Show up at 4. The whole purpose of these citations is to notify a defendant of what they're facing. And I certainly don't want to accuse Ms. Wisey of it. It does not look at all like the Department of Justice was involved in this procedure. And I can't imagine that if a law enforcement official or somebody from the DOA called an experienced prosecutor and said, hey, I issued a citation, but I want to proceed under a different theory of prosecution and a different code section. Is it okay if I just send a form letter? I can't imagine any lawyer in their right mind saying, yeah, go ahead and do that. They'd say issue a new citation.
Okay, so a couple of things. One is, you're not arguing that there's no mechanism for amending the charge. There's really got to be. And you're saying that the mechanism is issuing a new citation.
That's exactly right. It's almost, I'm sorry.
Well, I think you just said that, and I get that. And there really would be no specific time limit on that. They could do that tomorrow if they would choose to do that.
Subject only to a statute of limitations, and I frankly haven't looked into it, but we wouldn't be close to a statute of limitations under any theory that I can think of. What citation procedure is meant to be informal and not particularly burdensome on the state. So yes, issue a new citation, do the easy thing.
Okay. Okay, so that was one thing. And then the second thing was Mr. Bell really prejudiced by, is he prejudiced by the state's moving to amend the citation as of now? I mean, how does this prejudice him in an unfair manner, given that they have a right to amend at some point simply by issuing a new citation? Presumably they could do that tomorrow and there wouldn't be any statute of limitations problem. I guess the question I have is, how is he prejudiced if I grant the state's motion to amend?
I will answer that question, but I want to first, before I answer it, say I don't think the evaluation is prejudiced. I think the evaluation is whether the court has jurisdiction. And when there is a flawed charging document, I don't think the court has jurisdiction anymore. How is he prejudiced? We got to the eve of trial believing that he was charged with one code violation, and it wasn't until we learned from other defendants that, no, you better check the court file because the charging document in your hand isn't the same as in the court file. I think that's prejudice. Certainly prejudice in terms of whether he wanted to risk further prosecution by going back to the Capitol after having received his first citation because he thought his conduct was defensible based on the citation he received. The final point I'll make on that is this whole set of prosecution on some level is about the rules. It's the State Department of Administration arguing we have imposed new rules on the Capitol and the citizens of the state of Wisconsin and any other visitor has to follow our rules. Well, we also have rules of civil procedure, and certainly in a case about rules, the state should have to follow them.
Okay, thank you, Mr. Loeb. Well, what about that, Ms. Wisey? It seems to be undisputed that the citations, 2 of the 3 citations that Mr. Bell got were altered as filed as compared to the way they were issued to him, and specifically altered by changing it to add the VM charge in those 2 cases versus the subsection V charge that was originally on the citations.
Your Honor, the state's position is, as outlined in the written submissions, that even if those citations were amended inappropriately, that the state still has the right to amend its pleading once, as a matter of course, within 6 months. of the filing.
And that's because that's what the rules of civil procedure state.
Yes.
Are you aware also that we have certain, call them case processing standards we're supposed to follow that recognize the nature of these forfeiture cases as being somewhat different from ordinary civil cases? Our processing guidelines that have been adopted by the Chief Judges Committee requires that in order to be in compliance, we finish a contested forfeiture case within 6 months of the time that it's filed, and we're supposed to, in order to be in compliance with the rules, we have to be finishing 95%, is what the rule says, of our forfeiture cases within 6 months. If we were to apply that to these cases, how could we possibly be accepting amendments at the 6-month period? We had about 1,100 forfeiture cases filed last year. There's about 400, more than a third of them, I believe, are these cases. So if we were to accept your suggestion that you can amend once as a matter of course within 6 months, and that's what applies to normal civil cases, but we do tend to treat these somewhat differently, and I think those processing guidelines are a reflection of that. Any comments on why you should be allowed to wait 6 months to amend when we're told we should have these cases done within 6 months?
Because Wisconsin statute 802.09 parent 1 permits the party to amend its pleading.
I think you'd have to agree with Mr. Loeb, though, that we don't go about amending pleadings by altering pleadings that are filed in court and not serving a copy of that amended, if you will, I guess Mr. Loeb would say altered pleading on the other side.
You know, I think that he was given, from the letter that the Capitol Police sent, they did give that altered or amended citation along with the letter, because there is reference to some whiting out that I don't have, but that the citation would have been amended with that letter.
Are you sure about that? Because Mr. Loeb is saying, and I think Mr. Bell is saying that no, he never got an amended citation. He got a letter that came, what, presumably in the mail, Mr. Loeb?
Presumably, yes.
No, I'm not sure about that, Your Honor.
Well, does that make a difference?
You know, I don't think it ultimately makes a difference, especially with regard to (80209).
Well, if he didn't, I think we'd have to agree that that would be a irregular and probably simply wrong thing to do, to file a court document that says something different than the paper that's served upon the defendant. Wouldn't you agree with that?
I'm sorry?
Well, if he's saying he never got a citation, an actual charging document that sets forth the VM charge. He got the original citation that had the V charge. And then a couple weeks later, somebody sent him a letter saying, hey, there's a technical change, we're now going to go under VM theory and not the V theory. But he never got a charging document, you know, the ticket itself that said that. So it would seem to me it's at least irregular to do it in that manner, and as lawyers, we're not supposed to be filing things with the court that are different from the documents that the other party gets.
I would agree.
It seems like that's what happened here. Do you know any differently?
I don't know any differently, no.
Okay. Anything further on Mr. Bell's case? If not, perhaps we could just move to your next one, and Mr. Loeb.
The only final point I want
Sure.
to make, and it's in brief, so I will just simply mention it, is that I do not believe that the rule of civil procedure for amending pleadings would apply to a citation case, because it says that pleadings may be amended once within 6 months of filing a summons and a complaint. Because these cases do not originate with a summons and complaint, it's hard, if not impossible, to reconcile that rule with forfeiture procedure. And I think the recent decision of Bausch confirms that if you can't reconcile the civil procedure with the other statutory procedure, it doesn't apply.
Thank you, Mr. Loeb. Well, Mr. Bell, why don't you can have a seat, sir. Thank you very much. And we'll call Ms. Chuzet, who is also